Hi there, I'm Chin from TechUcon, and we are one of the delivery partners for the Accelerate IP program with New Ventures BC. Today, I want to talk to you about intellectual property. I think this topic is very interesting because when I was first exposed to intellectual property, I held many misconceptions about what exactly IP meant. And I think having the right understanding greatly helps both understand how to navigate your business, but also how to add value and generate revenue. And it's not just about protecting your assets or protecting competitors from copying you. So let's dive right into it. The first thing I want to talk about is some of the common misconceptions around what exactly is IP. When I was first exposed to it, my initial impression is more around, okay, IP is all about patents, it's all about protection. And why would you want to file a patent when you're exposing yourself in some cases? Maybe you may be better off operating under stealth mode and trying to get customers as quickly as possible. Yes, customers are important, but IP is a lot more than just patents. Every organization has intellectual property. The easiest way of thinking of it is everything that you can't touch in an organization, in a company, is an intangible asset, and that intangible asset is some form of an intellectual property. Every organization has valuable IP. The important piece is you need to be able to codify these intangible assets. If you are not documenting it, if you're not codifying it, it is tacit knowledge that you cannot apply and you cannot quantify. So an example would be if you hire a great salesperson and that person has a great network of potential customers. If you do not capture that network into your organization, once that salesperson leaves, you lose all of that information, right? So you need to document the relationships they have, document the conversations they're having so that you can continue that conversation even after your rep leaves. So number one is the documentation piece, quantifying it, making sure that you as an organization has access to that information. And then number two is understanding how to navigate and protect some of those assets as well. I want to go through a comprehensive list of examples of what might be intellectual property that you might not have considered yourself. So you don't have to have this checklist anywhere, but just understand that everything from concepts, ideas, software code, unique know-how, AI workflows, your business plan, your preferred terms with your vendors, pricing models, true to even if you're a manufacturer, your manufacturing processes, your algorithms, your formulations, your recipes, your SOPs, right? Standard operating procedures, operating manuals, your protocols, drawings, technical specifications, even marketing assets like your brochures, presentations, website, your brand, your name, your logo, your slogan, your colors, your images, your packaging, the data, obviously your customer data, vendor data, even unique access or licenses or certifications that you have. So, for example, if you are a mining company and you have exclusive rights to mine on a specific land, or if you're a logging company, you have road access to specific areas, that all is a form of intangible asset that is a valuable intellectual property as well. And in this day and age, the bulk valuation of any organization is more heavily weighted towards these intangible assets rather than their hard assets. As a matter of fact, like when you're thinking about going public through an IPO, or even when a company is considering acquiring you, the main thing that they're looking for is what intangible assets you have, right? They want to acquire you because they want to have access to your customers, to your technology, to your industry know-how, right? And part of that is also by acquiring you, they're getting your talent as well. So the better you can document and track this, the easier that conversation becomes when you need to talk about the valuation of your company. Patents, another thing to know is that it's not only about protection. As a matter of fact, when you patent, you actually have to have full disclosure of your invention in enough detail such that anyone can copy it. And if you are patenting, but you don't have the means to pursue litigation when someone does infringe and copy your invention, then what is the point of patenting? Obviously, another one is if you are patenting and you have no way of detecting if someone has actually gone ahead and copied your invention, again, it might have been a moot exercise, right? So make sure that you only consider patenting when the circumstances are ripe for it. And this is why you need to understand all the different type of IP assets and how you can best protect yourself and also build a strategy around it. So if it's not about protection, what exactly is IP about? IP is really about, at the end of the day, driving value. You not only driving value in terms of valuation of your organization, but also as a revenue driver. So for example, if you have certain protections in place, you can license out your IP for others to use. You can generate royalties over these licenses, right? For example, with Marvel or Lego, they license out their characters. If you have software, you can white label it so that your customers can use it. And when you have these things in place, then it becomes a lot easier to talk about both your business model and also kind of anchor down and justify that there is solid value in your organization. Patents aren't the only way. As you think about IP, the default is to think about patents, but you can also use things like copyright, trademarks, even trade secrets as well. Trade secrets aren't just about keeping things hush hush and hoping that no one copies. When you have the right trade secret documentation and protection pieces in place, you can actually pursue litigation and sue someone if you're able to prove that they have stolen or access your trade secret unlawfully, right? And if you can justify damages, and again, this justification needs to happen through that documentation. If you can say like, hey, these industry secrets or know-how is associated to this amount of revenue through our company, therefore we want to sue you for X amount of dollars, then that is where the justification comes in. So you need to be able to articulate that. Another important thing to know is that when we think about the value of these assets that we have, the value is going to differ depending on who is looking at your asset. So, for example, if you're speaking to an accountant and you're trying to come up with a company valuation, for example, they may primarily think about valuation from the perspective of cost. How much has gone into developing this intellectual property, right? How much have you invested into, registering those patents and kind of filing for protection? If you're speaking to an investor or potential acquirer, they're thinking along the lines of, what is market rate for a company of this size with a data set of this size with these type of assets? Or they're thinking about what's the potential in the market? Is it a growing trend? Is it dying out? And then on the other hand, if you're speaking to, let's say, a lawyer, they're going to be thinking more from the angle of how can I justify those damages that I mentioned? And that's where the value piece comes in a different kind of color depending on who you're speaking to. Lastly, the last thing I want to touch on before I wrap up this kind of IP 101 is understanding freedom to operate, or FTO for short. As you go out there in the market and when you are having those conversations with potential investors, or even if you don't seek out investors, if you're wondering, am I going to get sued? There is no such thing as 100% freedom to operate. You can never control if someone attempts to sue you. Someone may sue you even if they don't have legitimate grounds for claims. And you can also never control if someone does infringe and copy your technology as well. Instead, understanding FTO is more about understanding your rights. When you're clear on what rights you have, so for example, if you know that no one has patented your technology in North America, even if someone has patented it in Europe, you are free to operate. You're free to do it, right? So you need to know your rights first and foremost. And once you know your rights, then you'll know if those threats, those cease and desist letters, or someone threatening to sue you, if it's actually legitimate or not. Second to that, you also need to identify early what are the threats, who may come into your market, who might try to sue you, or who might try to patent overlying technology that would prevent you from serving your customers, right? And you need to have those response plans. So that is what an IP strategy is about. Because if you don't know what your threats are and you try to come up with responses on the fly, it's often not going to be a very good response because you're thinking about it in panic mode, right? So you need to understand, if someone's suddenly, if someone's suing you, do they have rights to sue you? Or let's say, for example, if you're operating and you're serving a customer, and then you find out later on that someone has actually patented the technology that prevents you from producing your solution to serve that specific customer, what do you do? Are you going to try and partner up with them, license their technology? Will you try to build around their technology? So maybe come up with a different type of solution? Or maybe you're going to go after a different market. Who knows? There are many, many different options on how to respond, but you need to first identify the threat and understand how to potentially respond to each of them so that you're not caught with your pants down when that situation arises. Um, so yeah, that's basically kind of some of the key basics. Tune in for the next video. We'll go into how exactly to build an IP strategy.